Welcome everyone to another Nova Consumer Talk. It's great to see some friendly faces. I would ask if it's a possibility for you that you turn on your cameras so we can have a face-to-face also with those who are listening, so it doesn't feel so only one way. Today we are discussing consumer conflicts and mediation. As we all know, we can have the most beautiful consumer norms, but if the consumer cannot enforce them, then they'll be completely useless. And so it's very important to always discuss consumer norms, but it is also of extreme importance that we discuss and constantly try to improve also the enforcement of those consumer norms. And today we are doing just that. We are discussing the enforcement of consumer norms by creating a dialogue around the topic of mandatory mediation in consumer disputes. In Portugal, we are very used by now to discussing mandatory arbitration. That is something that is part of our day-to-day, I would say, day-to-day in a broad sense, because we have a legal regime that has been studied. But as for mandatory mediation, the discussion has yet to start, or at least has yet to be deepened. So today we would like to give help in kicking off this discussion around mandatory mediation in consumer disputes, and we are lucky to have a great panel to do just that. We have with us Professor João Pedro Pinto-Ferreira, who is a researcher at the Nova Consumer Law. He has a PhD in civil procedure and is a visiting professor at the Nova School of Law. He is the author of several texts on the resolution of consumer conflicts, and it has been my pleasure also to, through many years, having the possibility to discuss with him so many topics around this subject. And I'm sure today will be no exception in hearing the great ideas that you always bring to the table. And to commentate the presentation, we now have, we are honored to have Professor Pablo Cortés from the Leicester Law School. He teaches a chair on civil justice and conducts very interesting research in the field of dispute resolution, civil procedure, and consumer law. Thank you so much for sharing your time with us today. We were planning on also having Professor Iris Beneur from the Queen Mary University of London, but unfortunately she's unable to join us for health reasons, and so we hope she gets better quickly. I will first give the floor to Professor João Pedro Pinto-Ferreira, then we'll have the comment by Professor Pablo Cortés, and then we'll open the floor to discussion. So feel free to, in the meantime, prepare your questions, write them in the chat if you wish to, or you can just at the end use the raise hand button when the discussion is open and speak directly, posing any questions that you may have. Thank you very much. João Pedro, the floor is yours.
Thank you very much for your kind words, Joana. It's always a pleasure to share a panel with you. I would also like to thank Professor Jorge Moraes Carvalho for the kind invitation to be here with you today, and Professor Pablo Cortés in advance for the commentaries. And of course, welcome one and all. I hope we can have a productive discussion on this topic. Let me now attempt to share the screen. Today, I'm going to speak to you a little bit about mandatory mediation in the Portuguese Consumer Protection Act. This is a relatively recent mechanism. It was introduced in 2019. And a basic outline of my presentation. My presentation will basically cover the following topics. I will start by addressing Articles 14.2 and 3 of the Portuguese Consumer Protection Act, which set out the mandatory mediation mechanism. And then I intend to address 3 specific questions. First, the question of the mandatory mediation and the right of access to the judicial system, which has already been analyzed by the European Court of Justice. The second, the scope of mandatory mediation in in-person and distance mediations, because we will see that when mediation is a distance mediation without a direct contact between the parties, we may need to make some adjustments. And finally, I will speak a little about the consequences for traders that refuse to take part in mandatory mediation. This question is especially relevant because mediation is based on the voluntary principle, and so the mediator cannot force a party to be in mediation. So we will see what can happen to the trader if it refuses to take part in mediation. So, mandatory consumer mediation in Portugal, the first topic. Article 14.2 of the Consumer Protection Act, introduced in 2019, states that consumer disputes of low economic value, we will also see what disputes of low economic value are subject to mediation whenever a consumer submits the dispute to a legally authorized consumer arbitration center and makes an express declaration to that effect. So it is not sufficient that the consumer submits the dispute to a legally authorized consumer arbitration center. It is also necessary that the consumer makes an express declaration to the effect that he intends to start a mediation. Article 14.3 of the Consumer Protection Act sets out what are consumer disputes of low economic value. All consumer disputes with a value not exceeding the jurisdiction of first instance courts in Portugal up to 5,000 euros. So these are the two provisions I will be analyzing today. Some observations on these provisions. First, in Portugal, as a rule, mediation is strictly voluntary, Article 4 of the Mediation Act, which makes these provisions of the Consumer Protection Act all the more interesting. The Mediation Act expressly sets out in Article 4 that the mediation process is voluntary, and I would emphasize this point, it is necessary to obtain the parties' free and informed consent for the mediation to take place. So, these rules on the Consumer Protection Act are clearly a deviation on the strictly voluntary basis of mediation according to the law, to the Mediation Act. This is the first point I would like to emphasize. Secondly, it is important to notice that this mechanism does not cover all consumer disputes, only disputes of up to 5,000 euros. And this is extremely important because it is extremely important to note that although it may seem an important limitation, in Portugal, most consumer disputes are of up to 5,000 euros. So most consumer disputes are included in this mechanism. So this limit does not affect most consumer disputes. And the second aspect, also very important, mediation is only mandatory for one of the parties to the contract, the trader. Remember that the consumer must, as I told you, it is necessary. Let me go back. Not here. Here. The consumer must make an express declaration to the effect that he intends to start mediation proceedings. So the mandatory consumer mediation mechanism is only mandatory for traders. Why only for traders? Well, it's connected with the rationale of the mechanism. The objective, though, the main objective is to raise awareness about mediation amongst traders, namely small businesses that very, very frequently do not know what mediation is about, what its rules are. Let me just make a further observation the reference to consumer arbitration centers is connected to a special feature in Portuguese law, the idea that most consumer mediations are carried out in consumer arbitration centers. In Portugal, in fact, the only ADR entities which are recognized for the purpose of the Consumer ADR Act and for the purpose of the Consumer ADR Directive and the ODR regulation are consumer arbitration centers. Yes, there are some other structures, namely municipal structures, that offer mediation services, but only consumer arbitration centers are recognized as ADR entities. So, in a nutshell, these are the main topics connected to Article 14.2 and 3 of the Portuguese Consumer Protection Act. First, the idea that it is a deviation from the strictly voluntary nature of mediation set out in the Portuguese Mediation Act. The second, that it does not cover all disputes, only disputes of up to 5,000 euros, although most consumer disputes are of up to 5,000 euros. Third point, the mediation is only mandatory for the trader, and this is connected to the idea that this mechanism is aimed at raising awareness about mediation amongst traders. So this about Articles 14.2 and 3 of the Portuguese Consumer Protection Act. Now let me discuss 3 topics that I believe are important in this context. 3 specific questions. The first question is whether mandatory mediation is compatible with the right of access to the judicial system. This question has already been discussed by the European Court of Justice multiple times, and more recently in this case, Menini and Rampanelli versus Banco Popolare case, the case 75/16, where the court basically, and following what it had already found in previous decisions, said, among other things, that mandatory consumer mediation mechanisms do not infringe upon the right of access to the judicial system per se, but, and this is very important, certain requirements must be met. This case, just to give you a little context, in this case, the court was called to assess this provision of Italian law, where the use of a mediation in banking contracts was a condition for the admissibility of legal proceedings, and that condition was regarded as fulfilled if the first meeting with mediator ends without an agreement. So this was the case that was being addressed in Menini v. Banco Popolare. Why did I choose this case? Because this case precisely takes into account a consumer mediation. Well, I'm not going to analyze the several requirements isolated. I'm going to try to see if the Portuguese mechanism meets or doesn't meet those requirements. What are those requirements? Well, I already start out by telling you that those requirements are met by Portuguese legislation, but let's analyze each one of them. First requirement is that decision may not be binding on the parties, and this is ensured in Portuguese law by the voluntary principle enshrined in Article 4 of the Mediation Act and in Article 27b. Article 4 states that the responsibility for the decisions taken during mediation belongs to the parties, and as a result, Article 27b states that the mediator must refrain from imposing any agreement on the parties. So there is no binding decision on the parties as a result of mediation. Second requirement, no substantial delay in bringing legal proceedings. Again, this requirement is met because, as a rule, in Portugal, consumer mediations must be concluded within 90 days. Yes, it is possible to extend that timeline, but only very limitedly. So this requirement is also met. Third requirement, the suspension of the period for time bearing of claims. Again, the Mediation Act provides for the suspension of that time period with the mediation protocol in Article 13.2. So this requirement is also met. Fourth requirement, no costs or very low costs. Again, consumer mediation is free of charge or available at a reduced fee for consumers. According to Article 10, Paragraph 3 of the Consumer ADR Act, so this requirement is also met. Means of access to mediation. Mediation must be easily available both online and offline. The Consumer ADR Act also provides for this. Both the requests for mediation and the mediation itself must be available both online and offline. Article 6, Paragraph 1C, and Articles 10, Paragraph 1 of the Consumer ADR Act. Finally, the requirement that may cause some more doubts as to interim measures, the possibility for parties obtaining interim measures. There is no specific provision in Portuguese law, but if we consider, on the one hand, the main features of mediation, namely its consensual nature, as we have already seen, and the mediator's lack of jurisdictional power, on the one hand, and the rationale behind interim measures, namely the periculum in mora, both these ideas suggest that mandatory mediation is not intended to prevent the parties from obtaining interim measures prior to mediation. So, in my opinion, this requirement is also met, although, contrary to the others, there is no specific provision in place. So, at the end of this analysis, it is possible to conclude, in my view, that the mandatory consumer mediation mechanism set out in the Portuguese Consumer Protection Act is compatible with the right of access to the judicial system. It basically respects the tests set out by the European Court of Justice. Second question, the scope of mandatory mediation. The question is now, what does the compulsive nature of mediation entail for traders in both distance and in-person mediations? And in-person mediations, in my view, it implies that traders must appear at the pre-mediation session, meaning that the trader must at least, at the very minimum, appear at the session where the mediator will basically explain what mediation is and what its rules are. I have a lot of doubt whether the compulsive nature of mediation requires anything further. Why? Because we must consider three aspects. First, the voluntary principle. Second, the rationale for this mandatory mediation. And if the rationale for mandatory mediation is to raise awareness about mediation, this objective seems to be achieved with the pre-mediation session, because the pre-mediation informs the parties on what mediation is and what its rules are. But thirdly, and possibly more relevant, I believe it may be counterproductive to force traders to continue in mediation, to take part in further mediation sessions, especially when mediation depends on a cooperative approach by both parties and in a mutual sharing of the interests underlying their position. So if the party really, after knowing what mediation is not interested in mediation, it may be counterproductive to require it to continue to a full mediation session. Regarding distance mediations with no direct contact between the parties, which are fairly frequent in Portugal. We are speaking about cases where basically the mediation involves a series of caucus between the mediator and each party. The parties may never communicate directly, and it will be up to the mediator to share the content of the private sessions with the other parties, to the extent obviously allowed by the principle of confidentiality. This happens fairly often in Portugal, and the question is, well, what is the scope of mandatory mediation in these cases? Well, in my opinion, traders must at the very least submit a substantive reply within a reasonable time to the center's first contact. In these cases, basically, the consumer submits the complaint, then the arbitration center contacts the trader, introducing itself, mediation, and the complaint. And what I am arguing is that traders must, at the very least, submit a substantive reply within a reasonable time to this first contact. What do I mean by substantive reply? Let me just be clear. What I'm trying to say is that in this reply, the trader must present his or her perspective about the dispute as submitted by the consumer. Third question, and the more concerning, the more troubling in my opinion. What happens if the trader refuses to take part in mediation? Yes, mediation is mandatory. Articles 14.2 and 14.3 of the Consumer Protection Act do not set out any sanctions for traders that refuse to take part in mediation. So, straight off, we can exclude a solution like the one I was mentioning you about regarding Italy, where the law stated that mediation was a condition for the admissibility of legal proceedings. That is not the case in Portugal, and it is not possible to get there without that being expressly provided for. So we need to. So the problem is, doesn't this allow traders that up until now systematically refuse to engage in mediation to continue to do so with no sanction whatsoever? Apparently so. And if so, what is the effect of this rule? So I'm going just to analyze two possible solutions to this problem, which for me is the main problem of these provisions, as they can endanger the objective. The first solution: the trader is liable under tort law. What is the problem? What are the advantages, and what is the problem? The advantage is that this solution, liability under tort law, does not require any legislative amendment. What is the problem? Well, the problem is in the requirements of this liability. There are two major hurdles. First of all, it is unclear, and I would tend to say that the answer is negative, whether the trader's refusal to take part in mediation may cause specific damages to the consumer. Because if it does not cause specific damages to the consumer, there are no damages, and the tort law test fails. This is the first question. There is a second question, which is even more difficult. Even if there are specific damages from that refusal, there has to be a causal link between those damages and the refusal to take part in mediation. Well, if the trader, and that would require proving that the mediation would have concluded with an agreement. Well, if the trader is not, refuses even to engage in mediation, it will be very, very difficult to prove that mediation would have concluded with an agreement. So the main problem of this solution is the requirements of damages and the causal link. A more promising option, in my opinion, is to defend that the trader is responsible for any and all costs incurred by consumers in subsequent judicial or arbitration proceedings, regardless of the content of the decision. Basically, this would mean that legal fees, that lawyer fees would be paid by the trader, even if the decision was, even if the case is ultimately determined for the trader. What is the main drawback of this solution? Two. The first, it would require a legislative amendment. The second, it appears it would mean a deviation from the general rules as to legal fees in the Portuguese legal order. And that would be basically what I would have to say. I think I have overreached a little bit, so I'm sorry for that.
Thank you so much, Professor João Pedro Pinto-Ferreira, for your interesting thoughts. You had me definitely thinking about some new things here. Professor Pablo Cortés, I now pass the word to you. Thank you.
Thank you, João Pedro, for this excellent presentation, providing a very thorough analysis of the Portuguese Consumer Protection Act and its requirement for mandatory mediation for traders with consumer disputes. I certainly agree with all you have said, in particular with your conclusions regarding the compliance of this new legislative requirement with the European case law, in particular with the Menini and Banco Popolari, as you mentioned, as well as the Alassini and Italia Telecom case, which I'm sure you're familiar with. I thought, well, as a starting point, I think it is, it is worthwhile to remind ourselves, as you touched when discussing Article 14, that mandatory mediation implies only the requirement to attend this the first meeting, the preliminary meeting, and I absolutely agree with you that it should not be further investigation on whether the other party has been sufficiently collaborative or not during the mediation process. That would lead to open a can of worms, as they say in the UK, or could also lead to discourage, I don't know, the issue of good faith in mediation. I think it can be a problematic one if it's to be enforced subsequently in a court case. I think something that struck me, in addition to European case law, I think it's worthwhile to make references to the right to access to justice and the right to a fair trial as enshrined in the European Convention of Human Rights, Article 6, and also in combination with Article 13, the right to an effective remedy. I think those principles should also underpin the justification for making mandatory mediation in suitable cases, like in consumer disputes of low value. Regarding your recommendations in terms of how to penalize a trader who has not attended the first mediation session, I also agree with you that maybe the third avenue may not be the best one, that maybe it's better to penalize on costs. And this is the position adopted in the UK, in particular in England and Wales, for commercial issues. there is a case called Halsey and Milton, which controversially the court said, this is called obiter dicta. This is not the main part of the judgment, but in that judgment, the leading judge stated that forcing parties to go to mediation, in his view, would be a breach of Article 6 to the right of access to justice, which many other judges subsequently sort of disagree. But most importantly, in that case, they set some guidelines to establish where one party has been unreasonable in not accepting an invitation to go to mediation. The invitation can come from the other party or can come as a recommendation from the judge. In those circumstances, the court agreed that it would be justified to penalize a party on the legal costs from the moment that the invitation to go to mediation was unreasonably refused, regardless of the outcome of the case, as João Pedro also recommended. I think this case has been subsequently complemented in the UK with a case called PGF2, SA and OMFS. It's a case from 2012 from the Court of Appeal, where Lord Briggs, which is currently a Supreme Court justice, he stated that if one party ignores an invitation to go to mediation, it will be considered prima facie, it will be presumed that that party had acted in an unreasonable manner. So I think we have already some examples in other jurisdictions that are willing to penalize a party who had not considered an invitation to go to mediation, let alone if that requirement is set in a statute, as it's the case in Portugal. So I think that it is crucial to set adequate incentives for in this case, for traders to ensure that they will at least attend the preliminary session. And they say that you cannot force horses to drink water, but if you bring a horse close to the water, there is every chance that the horse will drink the water. So I think the starting point is to ensure that parties at least, give it a go, try to explore mediation as an avenue to resolve the dispute. What other thoughts I had? Well, when I hear about the Portuguese model, I often think about what happens in Spain, which we also have a med-art system for consumer disputes. Of course, it is different than the one in Portugal. Indeed, mediation is not mandatory as a preliminary step to go to arbitration. But I remember reading an article by Professor Imma Barral from Barcelona, who also practices as an arbitrator, as a consumer arbitrator, and she said that mediations in consumer matters are often unsuccessful because the consumer does not understand what mediation is about and expects the mediator to act basically as an advocate in favor of the consumer. So I think it's crucial to manage the expectation of the consumer when attending a mediation session, especially in the first session. I think another element another model which I think it is interesting, and it's the one that they use in Italy. They call it conciliazione paritetica, or I like it to translate that as a representative negotiations for consumer disputes. This is a process whereby a representative of the consumer will meet with a representative of the business and will discuss the possibility of a settlement or a proposed settlement, which then is passed on to the consumer, who can either accept it or reject it. What is interesting is that apparently in around 90% of cases, consumers accept the recommendation made by the representatives. And And I think, I just read that, empirical research shows that when consumer does not have legal representation, as it is normally the case, they are more emotionally involved with the dispute, and sometimes it's more difficult for them to reach a settlement. It also has obviously the advantage of having a cathartic opportunity to express your frustration, to express your problem, and that has a lot of value in itself. But sometimes can hinder it can hinder the settlement when parties don't have legal representation, as I said, as is common the case in consumer disputes. So I think as we're moving to a variety of, especially moving to online dispute resolution, I think it's interesting to explore how other jurisdictions are dealing with these processes, in particular with regards to making it mandatory for the trader to participate. And I think I know the Italian model has been seen as a model, and it's being expanded a lot in Italy. So in terms of the UK, I think here in England, in many regulated sectors, it is mandatory for the traders to participate in ombudsman schemes. These ombudsman systems, they do have like a conciliatory stage at the beginning. You can, I think it is possible to call it mandatory mediation, in the sense that the ombudsman, in first instance, when he or she receives a complaint from the consumer, will explore the possibility of a settlement with the trader. And they do that in a way the consumer is, the ombudsman or the case handler communicates with the trader on behalf of the consumer. So this is what some would call, like caucus mediation, where the mediator meets with the parties separately, not at the same time. So in a way, the case handler or the ombudsman, pass on the complaint to the trader, and with the trader they explore a possible settlement, and which is then passed on to the consumer, which is obviously free to accept it or not. Now, if the parties don't reach a settlement, then they have the possibility to, then you move to the next stage in the ombudsman process, whereby the ombudsman will issue first a recommendation that becomes binding when it is accepted by the consumer. And in the UK, we have, in many regulated sectors across Europe as well, it is mandatory for traders to participate in these processes. So for complaints against utilities, electricity providers, gas, telecommunications, also financial institutions, in all these sectors, it is mandatory for the traders to participate in an ADR process when the consumer initiates the process. So I think there is some parallelism to the mandatory mediation system you are implementing in Portugal. Of course, for outside the consumer realm, we have for family disputes, for instance, in the UK, before you are able to go to court, you are required to attend a MIAN, which is a mediation, information and assessment meeting. Similarly, for employment disputes, there are also some prerequisites where parties have to explore what conciliation has to offer in advance of adjudication or litigation. So I think we're seeing a tendency that there is an effort to look at consensual dispute resolution methods, in particular mediation, in advance to more formal, more expensive, slower litigation, or indeed arbitration. And this is now being adopted in the UK also, in particular with a new court process, which is called the online civil money claims, which capture the majority of the civil claims under £10,000, where you have also many consumer issues that could fall within that jurisdiction, where the court first offers the parties to, the process is online. Parties could, in first instance, they can exchange offers to settle. And if that does not lead to a settlement, they can opt to a telephone mediation. Although it is not mandatory, what is interesting is that they have adopted an opt-out system. So the court process introduces a mediation stage which parties have to participate unless one of them expressly states that they don't want to do so. Because it's embedded into the court process, often parties participate in, and it's also because it's free of cost, often parties participate in the telephone mediation. It's also, this is also it's important when this is offered, and this is offered when a date for the trial has been allocated. So they say, well, the trial date will take place in 5 months. Before that date, if you wish, you can try a telephone mediation, which is free of cost. And that channel many cases to go through mediation, which also delivers a pretty successful settlement rate between 60 and 70%. I think at this point I need to note that the court process, this new process, will not penalize parties who do not try mediation. And I think it is possible to argue or to anticipate that maybe in time they will do so. So just let me clarify. English or British courts will penalize parties if one of them refuses to go to mediation, but they do that when parties have legal representation. They don't do that when parties, especially consumers, or don't have legal representation, what we often refer as litigants in person. And I think, while I understand the rationale behind this, I think that there is, it is obviously circumstances will be different if the party who is to be penalized is a trader who has legal representation, a trader who has a particular interest in effect creating barriers for the consumer to reach a final resolution by being not cooperative, by not participating in the mediation process. I think as a final point that I would like to make, I think the crux of the matter is in reality is to identify when mediation is suitable, when mediation is most suitable, and then channel those cases through mediation. And I think it's increasingly there is a consensus that mediation generally is suitable in advance or more costly and formal adjudication, at least to attend this initial meeting. So I understand that is also the rationale behind the Portuguese law. I think it's also important to channel cases where parties don't have legal representation, when we have unrepresented consumers. So at least they are given the opportunity to explain what mediation has to offer and how it operates. It's also to raise awareness, which I understand is also one of the rationale behind the Portuguese law. I'm going to the type of cases that will be suitable for mediation. I think typically cases where liability is not at stake. So when it is clear who is right and who is wrong, but it's not so clear maybe the amount of compensation. When we are also dealing with non-legal issues, I work as an adjudicator, arbitrator, dealing with cases online and against airlines, telecommunication providers, water providers. And some of these cases relate to customer services, to poor customer services, to businesses treating consumers really badly. And that's not illegal. But, and for that, adjudication, arbitration is not really suitable. for that, a mediation process, it's more suitable. In general, when we're dealing with also, when we're, or in addition, when we're looking for remedies that are not of a monetary nature, so when the best outcome could be maybe an apology or an explanation, I think for those type of cases, mediation would be, I think, more appropriate. So I think we're all trying to reach this, I don't know, promote appropriate dispute resolution, identify what is the best process. I think we need to investigate and to identify, you know, for which sort of cases mediation can provide the best course of redress. Well, okay, well, these are my initial thoughts. And if anyone has any questions or comments, I'd be more than happy to hear.
Thank you so much, Professor Pablo Cortés. I'll now open the floor to questions if you have some. While we wait, I'd just like to say that one of the main points that remain for me from your presentation, from all the examples that you presented, is that there are actually a lot of different solutions where you can have enforcement based on consensus, apart from mediation. And mandatory mediation has a lot of problems, as we have seen today. And maybe in Portugal, we could also try to consider other ways of solving consumer conflicts, in this case, based on consensus, that are not necessarily built as a formal mediation. That's what I thought was very interesting from your approach. Does anyone have a question or would like to make a comment? You can use the raise hand button if you like, or use the chat if you don't have a microphone or you prefer it that way. Professor João Carvalho has a question, so please.
Thank you very much. And thank you very much to João Pedro, Joana, and particularly Pablo. It's a great honor to have you here at the Nova Consumer Lab and the Nova School of Law, even at distance, of course. But it's the way we do things now with this strange situation in which we are. But it's really an honor for me and for us to have you here. I have two questions. One to João Pedro, or two questions to João Pedro. The first, the grammatical construction of Article 14, when it says to start relation. I'm translating to English, but we can lose the grammatical question in English. It says consumer disputes of low economic value are subject to mandatory arbitration or mediation. I'm going to say in Portuguese, estão sujeitos à arbitragem necessária ou mediação. I would say it's a strange way to put it. We would say to arbitragem ou mediação necessárias. Why do you think mediation is after arbitragem necessária? But of course it is mandatory here because are subject to, it has to be mandatory, and then mediation should not be here if it shouldn't be mandatory. I don't know what are your thoughts on this, and if you want to comment on this issue, or if it is only a question of something that was not very clearly included in our regime. The second question is the relation with consumer arbitration. The relation between consumer mediation and consumer arbitration, mainly in the Portuguese consumer arbitration centers. If the consumer wants to start an arbitration procedure, is it mandatory for him to pass through a mediation procedure in those consumer arbitration centers? Are the two ADR means connected in view of Article 14 of the Consumer Protection Act? of course, we have already discussed this topic in the last 10 or 15 years, I know, but in view of Article 14, do you think we can see here a connection? Can the arbitration center tell the consumer, no, you cannot start immediately an arbitration procedure, you need to pass through mediation if you want to have a mandatory arbitration procedure? It was the second question. The third question to Pablo. Pablo has already, if you don't mind, if I ask you the direct questions, you have already discussed this, but I would like to know your opinion from your experience, and you are one of the most experienced persons and professors and researchers on ADR systems in Europe, and you know very well at least the Portuguese, the English system, and the Spanish, of course, and the Italian, as we have seen, and other systems at the EU level. What system would you say is more effective? Where do you think consumer disputes are solved more effectively? And what is your opinion on the Portuguese system? I know you have already at least seen and discussed the Portuguese system. What is your opinion, and from outside, what would you recommend us to change in order to have a better system? Thank you so much again to João Pedro and to Pablo for being here. It's a great honor for me. Thank you very much.
João Pedro, I don't know if you want to start.
Well, thank you. The wording of Article 14.2 and 3, that's a very good question. I would say that the wording of Article 14.2 and 3 of the Consumer Protection Act is at the very least, and I'm going clumsy, a little bit clumsy. It's clumsy to the point where you can even doubt whether the intention was only to institute a more general more general mandatory arbitration mechanism, or whether mediation is also included. In my opinion, currently, mediation is also included, but you can discuss that, and you can discuss that especially on the basis that the law does not provide any consequence for the trader that refuses to take part in mediation. I would rather look past that and try to find a solution for that, because clearly the law currently provides that both arbitration and mediation can be mandatory. But that doubt is that was in fact my first doubt when I read the article, and I had to read it several times until I finally based my position. As to the second question, I believe that is a very good question. We have already discussed that several times. But today I would probably tell you that taking into account, considering Article 14.2, mediation cannot be mandatory on consumers. It cannot be mandatory by a legal provision, and the center cannot make it mandatory on the consumer. I believe that would be contrary to the spirit of Article 14.2. Article 14.2 clearly states that the consumer may or may not want to submit the dispute to mediation. Yes, it's true that in Portugal, normally mediation and arbitration are combined. They are, you can say, a pack. You take two for the price of one. Yes, normally you have first mediation and then arbitration. But I would say that Article 14.2 is now an important argument, in the sense that the Consumer Arbitration Center cannot say consumers, no, you can only access arbitration if you go through mediation. Because that would mean that the Consumer Arbitration Center would be forcing the consumer to mediation, while the law does not do so. So despite the fact that previously I would have considered that the rules on mandatory arbitration were only binding on the trader, and so the Consumer Arbitration Center could say, yes, you have the right to proceed to arbitration, but according to our rules, you need first to start by mediation. Now I would have more doubts on that.
Thank you. Professor Pablo Cortés, would you like also to add your thoughts?
Sure. Yeah, thank you. Thank you for the question. So, if I understood correctly, I was asked to comment on successful ADR models and also the Portuguese system, whether any suggestions for improving it. In my experience, and relying really on research of others like Chris Hodges from Oxford, which has explored ADR in many European countries, it shows me, or it seems to me, that the most successful models, they tend to be specialized or sector-specific dispute resolution schemes, where the third neutral parties, mediators, arbitrators, they have sectorial expertise, and they are respected by the industry, by the traders, by the businesses. The same like the ombudsman models, they tend to be specialized in their field. So I think that ensuring specialization in the sector, I think it's an important component of developing a successful ADR model. And in terms of the process itself, I think it's important to pay attention at the type of disputes, or the paradigmatic or the typical type of disputes that the ADR scheme needs to resolve. Let me just share an example. In my experience, I deal with, I work as an online arbitrator dealing with aviation disputes that passengers have against airlines. By and large, these disputes relate to cancellations and delays. And this European regulation that is very clear, Regulation 261, that basically, in sum, it says that if it was the fault of the airline, then they have to compensate, and there are fixed amounts of money that are established in European law for delays, depending on the distance of the flight. But if the cancellation or the delay was caused because extraordinary circumstances, bad weather, or COVID, indeed, then the airlines are not required to compensate. The airlines have to show this type of evidence. So the point I'm trying to make is that for this type of cases, to me, an adjudicative process like arbitration seems more suitable. In fact, in the UK, there were 2 approved ADR bodies to deal with this type of cases. One was an adjudication arbitration system. The other one was an ombudsman. The ombudsman, after 1 year of operation, changed then to become an adjudicative process as well, because there is not much room for negotiation when you are basically applying the law to see who's responsible and who has to, whether the consumer is entitled to compensation or not. So I think it's important to identify the type of cases, the type of process that best match the process, and fitting the forum to the fuss, as they call it in the US, and also to ensure that there is expertise from the third neutral parties, in particular, from the scheme in general, to address those type of cases. About the Portuguese model, I very much like the fact that it incorporates mediation as an optional process for the consumer, and then it has arbitration, but in particular the fact that it's mandatory. And I think this is an important component for the successful ADR scheme, that the fact that it must be mandatory for traders to participate. Otherwise, they won't participate. And And when that is the case, and I'm not sure how it currently is in Portugal, but I know in the UK, it's also a prerequisite for the consumer to show that they first approach the trader and try to resolve the dispute directly with the trader, and that the trader has been given enough time, which is usually like a month, to decide on the consumer's complaint before the consumer is able to escalate the complaint to arbitration or to mediation. So I think it is important that parties have incentives to resolve the disputes directly by themselves when possible, and also, you know, to obviously to consider mediation in advance of arbitration. And the fact that the Portuguese model makes it mandatory for traders to participate in the process, I think that is a very good, a suitable system process. So these are my thoughts on these questions.
Thank you. Unfortunately, our time is up. I still have many questions, but I think definitely today was a very good contribution to this discussion. It is a discussion that needs to continue in Portugal. From a practical point of view, the centers need to know what actually they have to do to implement the law, but also from a theoretical point of view, which solution is best? Are we going in the right direction? So thank you both so much for your ideas today and for contributing to this ongoing debate. Thank you also all for attending, and we'll see you again soon. Thank you so much, everyone.
Thank you. Thank you very much for the invitation.